Hello, and welcome back to Constitutional Fraud. I'm your host, William Toppi. In this episode, we'll dive into a troubling event. A Massachusetts Superior Court judge seemed to completely ignore my constitutional rights, using deception in eliciting their waiver. This moment not only affected me, but also raises questions about the Massachusetts criminal justice system. Before we dive into the details of this critical episode, I want to emphasize the importance of the issues I'm about to discuss. Our United States Constitution guarantees certain fundamental rights to every citizen, and the criminal justice system is supposed to protect and uphold these rights. In this episode, we'll explore how the very system designed to be fair, impartial, and unbiased failed to do so. And we'll take a look at the tactics used by those who should have been guardians of justice and uncover the disturbing truth of what really happened in that courtroom. I want to make it clear that my intentions in sharing these experiences is not just to shed light on the injustices I faced, but also to raise awareness about the flaws in our legal system that can and do affect everyone. I hope I can inspire positive change. Let's begin this journey into the heart of constitutional fraud. First, let's recap what happened during the lobby conference that took place in my absence, leading up to this waiver of rights. My specially appointed counsel, Debra DeWitt, insisted on lobbying the case without my presence, even stating that there would be a plea before engaging in any lobbying efforts, raising questions about her intentions to begin with. Then, she clearly states having a conflict of interest in representing me, related to an accusation that I kicked a dog during the alleged crime. This conflict of interest statement should have immediately raised concerns because it highlights her personal bias as a dog owner, potentially affecting her ability to represent me objectively, irrespective of the case's actual facts or strengths and weaknesses. If these two key issues weren't cause for concern, what happened next leaves no doubt about her intentions. DeWitt interrupted the court to impose her own preferred sentence of 6 to 30 months by falsifying the history category level of her client, thus elevating the potential sentence he would face. The actual and correct history category level suggested 0 to 24 months of incarceration. DeWitt created a false starting point that belies her later recommendation of 1 year or time served. Next, DeWitt proceeded to suggest that her client's involvement in the crime was significantly influenced by drug-related factors. However, she relied on my criminal record to support this assertion with a conviction of 3 Valium pills in 2010 and a drug trafficking conviction from over 20 years prior. Neither the police nor the victim ever made such claims regarding my involvement with drug use. In fact, no one has presented this accusation to the court, and I never made this claim to the court either. Furthermore, DeWitt's actions took an even more troubling turn as she made false statements of the facts, committing perjury and perpetrating a fraud upon the court. In her statement, she claimed that a witness identified her client from a Facebook photo which the police were supposedly unaware of. This claim is highly significant because DeWitt's motion to suppress evidence explicitly stated that the police had presented the witness with the Facebook photo, and the motion was even supported by an affidavit. This claim, regardless of whether the court addressed the motion, is significant. Essentially, DeWitt knowingly provided false evidence against her own client using her own suppressed evidence, all the while previously inflating the potential sentence by falsely elevating my history category level under the sentencing guidelines. I must incorporate one last important detail here. Namely, DeWitt was in possession of 2 handwritten letters from the co-defendant, Ebby, who had agreed to testify against her client. In these letters, he asserted his innocence in direct contradiction to his plea agreement with the Commonwealth, admitting guilt and implementing me. Strangely, DeWitt refused to use these letters in my defense. Even the prosecutor, Tasnin Chowdhury, contributed to this web of falsehoods by making inaccurate statements about the case, by stating that Ebby and I were painting in the house and then decided to break in, and that a safe was broken into. These are inaccurate statements. This so-called lobby conference was a far cry from a legitimate negotiation. The facts presented were flawed. The sentencing guidelines were grossly inaccurate. The accusation of addiction driving the crime was never substantiated or even questioned. And there was a complete absence of plea bargaining with me or in my favor. Instead, all of the bargaining revolved around the co-defendant, Ebby, who, mind you, was already facing parole and probation violations before any time involving this crime. What's even more noteworthy is that Ebby has a brother who was a police officer and another brother who was a court officer. Despite his prior convictions for similar offenses, his parole status, and these familial connections within the law enforcement and judicial system, all the concessions were offered exclusively to him. The lobby conference, which purportedly determined my sentence, didn't involve me at all and offered no concessions. In fact, it resulted in an even more severe sentence. Judge David Ricciardone, a self-proclaimed expert in the plea bargaining process, who oversaw this lobby, not only permitted this injustice to unfold in his courtroom, but also became an active participant in the charade. It seems like everyone had a go at manipulating me, and this was only possible because David Ricciardone allowed, and in fact, partook in this scheme, as you are about to see for yourself. And now, a word from our sponsor. This episode of Constitutional Fraud is brought to you by the Sixth Amendment of the United States Constitution, bringing you such guaranteed rights as the right to a public trial without delay, the right to a lawyer, the right to an impartial jury, and the right to know who your accusers are and the nature of the charges and evidence against you. However, you are about to bear witness to how easily a person can be tricked into waiving these guaranteed rights by fraudulent means. And now, back to our episode. I want to remind you about the fact that leading up to this date, I had been held on a suicide watch and subsequently punished in the hole on 23-hour-a-day lockdown with another man for a week. I was then transferred to the Billerica County Jail where my wife's boyfriend, who was present in the court, works, and the fact that I was confronted by him at that jail. I was then transported to Lowell several times for court, only to be informed that court was canceled. I was then transferred back to the Plymouth County Jail from the Billerica County Jail, and subsequently transported several more times to Lowell for court, only to be informed that it was canceled again. After this torture, I finally arrived at the Lowell Superior Court on December 17th, 2014, and was placed into the communal cell with 3 other men. I was utterly exhausted, dehydrated, confused, and consumed with fear. Attorney Debra DeWitt came in front of the holding cell to inform me that she had lobbied the case without me. She then told me that my wife's boyfriend was present in the court and that the judge was David Ricciardone, the same judge who refused to lower my bail $1 or offer any other alternatives to the bail conditions. She then proceeded to inform me that she could not secure a trial date for another 6 months, telling me that if I didn't plead guilty right now, today, I would have to go back to either Billerica, where my wife's boyfriend worked and I was in fear for my safety, or I would go back to Plymouth, where I was losing my mind for the past year, feeling suicidal. DeWitt informed me that she was requesting time served, but that it would be up to the judge. She did not inform me of all the fraud that took place in the lobby conference. Her conduct throughout the legal proceedings surrounding my case raises serious ethical and legal concerns. However, and this might come as a surprise, none of it even matters. Not that it doesn't matter, but it's contingent on a significant factor: the waiver of my constitutional rights. Judge David Ricciardone's participation in such a lobby conference where justice and due process were compromised raises questions about his own commitment to upholding the law and ensuring a fair trial. As a judge, he had a duty to protect my rights and ensure that the legal process was conducted fairly. His failure to do so, particularly in light of the numerous ethical violations occurring in his courtroom, demonstrates a disregard for these fundamental principles. David Ricciardone's conduct in this case raises significant ethical and legal concerns. His failure to address conflicts of interest, verify false statements, protect the rights of the accused, and his participation in a fraudulent process all cast doubt on the integrity of the legal proceedings. His actions and inactions during this case are deeply troubling. The most troubling aspect of David Ricciardone's involvement in this case comes to a head in waiver of rights. In this instance, we come to the pivotal moment of the requirement that a person waive their constitutional rights during the plea bargaining process of our political criminal justice system. Without these plea bargains, our entire justice system would collapse due to the amount of criminal cases on the dockets. However, there are safeguards in place to ensure a fair and impartial process, and this involves the required waiver of a person's rights before they can be legally sentenced. In accordance with this procedure, David Ricciardone informed me that he was going to ask me a series of questions designed to determine whether I was entering the plea voluntarily and with full understanding of its consequences. As part of this equation, he let me know that if I go ahead and answer any question that he puts to me, he can only assume that I understood the question before I answered it. He begins this requirement by producing a document entitled Waiver of Rights. However, this document was all wavy and blurred, with portions missing from it. He examined it and asked me if I read and understood it. Clearly, he could see for himself on examining the document that it was altered and not in compliance with a document to be presented as evidence in a court of law. A document that actually waives a person's guaranteed constitutional rights. He then proceeded to ask me other questions about my age, mental illness, and whether or not I had taken any medications, the standard questions that are required. However, when David Ricciardone came to the part of what was lobbied in my absence, he went off script, way off script. He actually lied to me and used deception, and then asked me if I understood his lies to be the truth. Let me explain. During the plea bargaining process, Judge David Ricciardone mentioned that he had spoken with both the prosecutor, Tasnin Chowdhury, and my counsel, Debra DeWitt, regarding their recommendations. He stated that the prosecutor was seeking a sentence of 3 to 5 years, while my attorney was advocating for 1 year, or time served. Ricciardone then informed me that he intended to follow certain sentencing guidelines, which he said amounted to a maximum of 2 to 2.5 years of imprisonment. However, he didn't clarify what these guidelines were or how they were calculated, and failed to disclose that he was actually adopting the false history category level proposed by my own counsel, Debra DeWitt, without mentioning that the correct history category level, based on my convictions, suggested 0 to 24 months of incarceration, before asking me if I understood. After this, David Ricciardone veered further from the script, setting aside both the guidelines he mentioned following and his role as a judge. Despite being positioned as an expert in the plea bargaining process, he proceeded to continue the lobby by negotiating the terms and conditions of the plea directly with me in open court. Ricciardone expressed interest in imposing a 2-year probation, emphasizing that I should understand the potential consequences of accepting probation for breaking and entering. However, he failed to inform me that, according to the Massachusetts sentencing guidelines, the committed sentence would always be tied to the underlying offense, which in this case was the breaking and entering charge. Truly, David Ricciardone knows that I can't possibly understand that he has been lying to me about following the guidelines. My confirmation of understanding his lies as the truth is a shocking disregard for his oath of office, his duties as a Superior Court judge, and for the laws of the state of Massachusetts, and ultimately his disregard for the Constitution of the United States of America. This action alone, irrespective of the other ethical violations of my especially appointed counsel or the Commonwealth's prosecutors, renders this waiver in the following sentence that was imposed upon me voided by being obtained by fraudulent means under color of law. This is not an accusation of perceived actions. This is all based on concrete evidence and is documented in the established rules and laws of the state of Massachusetts and the United States Bill of Rights and Constitution. I said I would remain objective in the introductory video of this series, and I have been. I can't be any more objective than concrete facts that are verifiable by court records and the Massachusetts sentencing guidelines, as well as the code of conduct that governs attorneys and the judiciary. I want to remind you, this case was investigated by the Committee for Public Counsel Services and examined by the Massachusetts Appeals Court and the Massachusetts Supreme Court, which both denied the appeal without any hearings. This episode has been brought to you by the 6th Amendment of our United States Constitution. Be sure to watch part 2 of this episode, where I will produce the actual waiver of rights that facilitated my unlawful conviction using the plea bargaining process of our political criminal justice system by an expert himself, David Ricciardone. The next episode in the series will be Victim Impact Statements. In this episode, we will delve into both the named victim's statement to the court, as well as the Commonwealth's further statements on behalf of the alleged victim of the long since dismissed charges. We will also examine David Ricciardone's official statement that he made for Prosperity, consoling both the named victim and the alleged victim, as well as his condemnation of me. Until next time, I'm your host, William Toppi. Remember, our pursuit of justice begins with you.